Legalese alert. Okay, I've been aiming to do this video for quite some time, and I'm really pleased. I had to make sure that I wrote it down because there's so much contained within these 104 pages. I'm aiming this at Scott Rose, and I'm also going to just kind of put this video up on Facebook to kind of get anybody else's attention who has this, who may have a legalese kind of mind. Pedersen versus OPM, Office of Personnel Management, is the case that I'm talking about today. It's basically a case against DOMA coming out of Connecticut, and there are Connecticut couples, Vermont couples, and New Hampshire couples who are married under the laws of their state, but the Office of Personnel Management doles out benefits to married couples who are recognized federally as married, and they have denied couples certain benefits under the law. So I'm going to get right into it. Okay, so the main couples are from 3 states that they're currently married under the laws of Connecticut, Vermont, and New Hampshire, and have tried to get benefits regulated by the federal government. However, due to DOMA, they cannot. DOMA was passed on September 21st, 1996, after passing both houses of Congress with large majorities. The law was made to say that only a man and a woman would be considered married. The law's intent was to curb an orchestrated legal assault being waged against traditional heterosexual marriage by gay rights groups and their lawyers. That was poised to achieve its greatest breakthrough. The breakthrough referred was a decision from the Hawaii Supreme Court in Bayer versus Levin, which allowed the Hawaii revised statute that denied same-sex couples access to marital status and the benefits given to married couples, and recognized sex as a suspect class for purposes of equal protection analysis under the Equal Protection Clause of the Hawaii State Constitution, mandating satisfaction of strict scrutiny analysis, which is the most rigorous form of constitutional scrutiny, and in order to withstand a challenge to its constitutionality under the Hawaii Constitution. Layman's terms, simply, there was a decision saying that this statute is unconstitutional and that it has to pass a very high bar of scrutiny in order to withstand constitutional analysis under their state constitution. So with that in mind, the House report says that they didn't want a newly coined definition of marriage to be foisted upon the unwilling Hawaiian public, and that there was a possibility that other states could, through a protracted and complex process of litigation, be forced to follow suit. DOMA affects over 1,100 plus rights that denied to thousands of legally married same-sex couples, and it was rushed through the government with no hearing from economists, historians, or specialists in child or family welfare. Due to DOMA, a couple was denied family medical leave because their spouse is a woman. A man was denied pension benefits from his late husband, who worked as a chemist at Bayer. 2 couples were denied nearly $6,000 combined, and 2 other couples would have saved a combined $700 a month if they were united under one health insurance plan. Blagg's arguments are as follows, that the couples who were denied the amended tax returns have no standing to challenge the law because it is the IRS they have to deal with. However, in a letter given to a plaintiff, DOMA is cited as the reason that they cannot get that amended tax return, and thus that money back from the state, from the federal government, and they cite DOMA. So therefore, the plaintiffs is standing. They also argued that the dismissal of Baker versus Nelson in Minnesota was binding precedent in the case. However, it was a matter of state law regarding Minnesota and limiting of marriage to heterosexual couples there, and the couples are already married in their state law. So Baker really has nothing to do with the current case, and also the dismissal is a slender reed on which to rest future decisions. They cited Morse versus Republican Party on 1996. And she also sums up that DOMA does in fact impact a fundamental right. Now she says here equal protection. She gets into that. The Equal Protection Clause of the 14th Amendment commands that no state shall deny to any person within its jurisdiction the equal protection of the laws, which is essentially a direction that all persons similarly treated or situated should be treated alike. And she cites City of Cleburne versus Texas versus Cleburne Living Center, where they did not want an individual. They blocked a permit for a house for mentally retarded individuals, and they said, no, you can't do that. The house stays, or the house can now go on. She mentions the Fifth Amendment pledge of equal protection is exactly that of the 14th when scrutinizing a law. When one law distinguishes a class from another, it must have a legitimate government interest and be narrowly tailored to protect that interest. In other words, it has to protect the government's interest, and that they're going to make it as little as a burden as possible. If a law doesn't burden a fundamental right or a suspect class like race, gender, national origin, or religion, it will stand so long as it bears some rational relation to some legitimate end. They're citing Romer versus Evans, which cites Heller versus Doe. So that in mind, they must determine what level of scrutiny will apply to this case. Suspect class. Plaintiffs say that DOMA should be subjected to heightened scrutiny because it discriminates based on sexual orientation, and it disparately burdens the fundamental interest in maintaining existing family relationships. In order to look at heightened scrutiny, they must assess the history of invidious discrimination against a class burdened by legislation, whether the characteristics that distinguish a class indicate a typical class member's ability to contribute to society, whether the distinguishing characteristics are immutable or beyond class members' control, and the political power of the subject class. So the first point, Abel versus U.S. says that the earliest and most dramatic legislation against gay people was enacted by any government was of the Middle Ages, when the laws were passed by the European conquerors of Jerusalem by imposing death by burning of homosexual men. And they say the Nazis also persecuted gays along with Jews, gypsies, and other groups, using the pink triangle to designate homosexuality. Now, on a side note, paragraph 175, which was in German law up until 1994, when the Allies liberated the concentration camps, most of the gay individuals were forced to serve out the rest of their sentences under paragraph 175. And then regarding the immutable characteristics, plaintiffs say that that sexual orientation is immutable or beyond class members' control. And Blagg says that many homosexuals have changed their orientation, and this is not a part of suspect classification. The court also says illegitimate children and undocumented persons have suspect classification despite their ability to leave said class. So if that line were followed, many African Americans wouldn't be subject to strict scrutiny because some of them have features that are consistent with Caucasians. Now, the political power of the subject class. In order to state the political powerlessness of a class, they point to the 41 states that have passed statutes or constitutional amendments to ban marriage between same-gender couples. Point most recently to North Carolina, that there are no federal prohibitions afforded to regarding employment, housing, public accommodations, and under Title VII, a gay person cannot bring a claim based on sexual orientation. And lastly, gay officials are underrepresented in political office in proportion to the population of gay and lesbians. And those are few that they use to demonstrate the point of suspect classification. In order to counter, Blagg points to the nomination of 4 openly gay judges and the confirmation of 1. But the court says since there are 874 authorized Article III judgeships, federal ones, and there are approximately 3.5% of Americans who are homosexual or bisexual, there would have to be at least 30 to reflect the population. She points out that judicial appointments do not reflect the political power of a subject group to rectify discrimination by legislative means. Political power, Blagg points to California's SB 48, which teaches the accomplishments of gay and lesbian individuals to American history. But the court counters and says that the Don't Say Gay bills have been introduced in Tennessee and Missouri following the passage of California's bill. and there was also an initiative to repeal it, but it failed to get enough signatures. That's my side commentary. Blagg points out Rhode Island Civil Union Bill, which is a weak bill, New York legalizing marriages for gay and lesbian couples, and repealing of Don't Ask, Don't Tell. Court points out, hey, Rhode Island's legislation doesn't show any meaningful political power in light of the 41 states that have banned the right to marry for gay and lesbian couples. Further analysis also shows that the backlash against the LGBT achievements is enough to show that there is enough political powerlessness, as our allies are often unreliable, and though it is a so-called corporate lobby for gay and lesbians, the court points out that the No on 8 crowd raised more money than Yes on 8. But yet the measure still passed, Proposition 8. From the ruling, she says this: Blagg has failed to demonstrate the alleged gay corporate power, the ability of gay men and lesbians to raise money for advocacy, or the election of fair-minded candidates in 2008 has actually transferred into an ability to eminently end discrimination, prejudice, and prevent favorable outcomes as Proposition 8 or Don't Say Gay type legislation. This satisfies heightened scrutiny for review because DOMA fails to pass constitutional muster under even that. So now, rational basis. The law must bear a logical relationship to the purposes it purports to advance, and by requiring that legislation bear a rational relationship to an independent and legitimate legislative end, we ensure that the classification are not drawn for the purpose of disadvantaging the said group by the law. Reasons for passing DOMA: to make sure that society protects its interest in making sure children are raised in marital households, to avoid a social understanding or creating a social understanding of bearing, begetting, and rearing children apart from marriage. Blagg argues that the extending federal benefits to opposite-sex couples make marriage more appealing, and that it encourages raising of children in a marital relationship, and allowing same-sex couples to marry would somehow devalue that. It also would make opposite-sex couples procreate outside of marriage. They point to a Scandinavian study which shows a reported increase of out-of-wedlock births following the introduction of domestic partnerships and marriages between the people of the same gender. First of all, there is no such thing as Scandinavia, at least, well, there is no such country as Scandinavia. Usually that refers to I believe Finland, Norway, and I want to say Sweden, or maybe Greenland, because I think there's like a three-prong, like there's a small little area, kind of like near Finland and all that up there, and maybe it refers to Greenland as well. I'm not sure, but that's just a whole. That is referred to as Scandinavia, but it's not one whole country. A lot of people who cite this make it seem like Scandinavia is one big country, and it's not. So anyway, plaintiffs say that the study relied on by Blagg and Congress say that there was already a trend in non-marital births in the country since the beginning of the 1970s, long before domestic partnerships were recognized. Also, excuse me, they say that having children has never been a condition for marriage, and that heterosexual couples who can't have children on their own are not denied such benefits. Lastly, they say that denying federal benefits under the guise of protecting children disenfranchises children of gay and lesbian parents, and that DOMA doesn't stop same-sex married couples from adopting children either. That those children would be disadvantaged by the denial of resources and benefits when their parents pass away, and all due to sexual orientation. The court shreds the study by saying that growing individualism, women in the workforce, contraception, and other social trends have increased out-of-wedlock births. The court also says that it is not rational to blame the out-of-wedlock births on same-sex couples being recognized as legal entities, because that would mean that all of a sudden, same-sex married couples would erode and discourage couples from marrying before procreating. The study also acknowledges a host of later emerging factors which may have contributed to the acceleration of the trend of extramarital procreation, including the expansion of the welfare state, which renders each individual independent and undermines the need to rely on family structure to provide for and raise children, and which increases taxes, therefore driving women to the workforce, further increasing their independence. Regarding children, the states that the couple reside in allow them to adopt children like any other couple can. She says here, DOMA deprives these adopted children of governmental services and benefits desirable, if not necessary, to their physical and emotional well-being and development, creating an increased potential that they will become a burden on society. She also says that denying federal benefits create a burden for homosexual couples and accords a benefit to heterosexual couples and disincentivizes marriages of heterosexual couples. Many state bodies have said that homosexuality does not impair the ability to parent children, and have passed laws removing prior legal barriers to the adoption of children by same-gender couples. Also, DOMA has no real effect on the same-sex couples as children, as it involves the issue of marriage, not child rearing. However, DOMA does make same-sex couples pay more in taxes, which in fact depletes resources of gay and lesbian couples and their children. Thus, DOMA contradicts the argument that it protects all children. So in sum, there is no rational relationship to DOMA and child rearing, and it simply shows a bare intent to harm the children of gay and lesbian couples. She also notes DOMA treats gay couples as inferior for the purposes of federal law. Now she points to traditional morality. As there are denominations that are supportive of same-sex couples or same-gender couples and marriage rights, she says that this cannot be used as a reason for DOMA's existence. Moral disapproval of a group, a bare desire to harm, is an interest that is insufficient to satisfy a rational basis under the Equal Protection Clause. That's from Romer versus Evans. This is called animus, and throughout the House report, it is evident that this was the intent and remains the intent of the law. Going to protecting government resources and government fisc or money. Since the House hadn't had hearings. Try saying that 10 times fast. How could they know how much money would result, more or less, into the federal treasury if same-sex couples were legally married in the eyes of federal law? A report from the Congressional Budget Office, June 21st, 2004, shows a small increase in the revenue by less than $1 billion in each of the next 10 years. Conserving public resources is not a legitimate reason for discrimination, especially when in fact the budget will show a small increase from recognition of same-gender couples. Blagg presents no evidence to the contrary, and it would not strain government resources. In fact, it would help the federal government's bottom line. Concern for public fisc is now tossed out. Protecting state sovereignty and democratic self-governance. First, DOMA was to preempt a court decision legalizing marriage between gay and lesbian couples, and by limiting the full faith and credit clause. Now, full faith and credit clause means that a marriage solemnized in one state, in Missouri, would be recognized in New York, would be recognized in Tennessee, Arkansas, Alabama, and every other state. Hence, Congress has the ability, according to the Constitution, to limit the full faith and credit clause. And also, they were able to remove any threat of federal litigation out of the equation and let states and officials decide how to deal with it. They say that the court should reserve the issue for the legislative officials and the people. However, the fact is that that Connecticut, New Hampshire, and Vermont have decided the question and afforded same-gender couples the right to marry, and it is the role of the court to decide whether or not a law offends the Constitution. That was set as a precedent in Marbury versus Madison, I believe. There were midnight judges that Thomas Jefferson appointed, and Marbury sued to get his judgeship, and that was struck down. And I don't know why he appointed them at the very last moment, but I don't know. They're often called the midnight judges in law. The concern Blagg raises is interesting because self-governance brought about the very marriages of the couples that are bringing the suit. DOMA abridges the rights of the state to confirm marital status of its citizens, and the federal government depended on the state to tell it who was married. And now the federal government is turning around saying that the state's definition of marriage is not valid for federal purposes and therefore offends the thought of protecting state sovereignty. Maintaining uniformity regarding federal benefits and using restraint in implementing new definition of marriage. Blagg states that the long-term effects of marriage between two people of the same gender is unknown and that the court should proceed with caution when making significant changes to social policies, and this is the fact why DOMA was enacted. In that way, it remains consistent. Plaintiffs argue that the consistency is not there with DOMA and it doesn't advance such In fact, it creates confusion for tax and benefit purposes, where they can file jointly under state law, but separately and as single people under federal law. Analysis provides this. In order to justify their inclusion, they say that it is best to wait until same-gender marriage has proven itself in order to accord its benefits. However, to allow a reasonable explanation to continue discrimination would eviscerate the doctrine of equal protection. Uniformity argument bears no rational relationship between Section 3, where DOMA infuses complexity and inconsistency into the conferral of federal benefits where the federal government hasn't injected itself. Prior to DOMA, every single heterosexual marriage varied pursuant to the laws of the state, including age where parental consent was not needed, and by deferring to state law, the government simply recognized these marriages despite differences across state lines. DOMA excludes same-gender couples, which shows an inconsistency in the federal regulation of benefits. So, in sum, yes, 21 minutes, and now I am concluding. She says the protect children aspect is not there with DOMA, as it doesn't abridge adoption rights, which are accorded at the state level. And the so-called uniform distribution of federal benefits bears no rational relationship to Section 3 of DOMA. Therefore, Section 3 is unconstitutional. Plaintiff's summary judgment is granted, in other words, a non-jury trial where the judge decides. And all that is basically all that means. And Blagg's motions to dismiss is denied. And it is so ordered. Usually they say it is so ordered. The Honorable Vanessa L. Bryant. So I think there's nothing further to say. Your Honor, I rest my case as there is nothing further to say that I did not say in the ruling. Thank you, YouTube.